Not present. मूव करने के बाद होगा ना, वही तो मैं कह रहा था। श्री माननीय मेंबर श्री विवेक के तनखा जी।
Thank you, Chairman. Vice Deputy Chairman. Yes. Thank you, Chairman. This is an opportunity to speak on a subject where we support the bill, but we want India to emerge as a real arbitration center. And whatever steps we've taken so far are not good enough to realize the dream of people of India, the legal community, and the business community. I have no reason to oppose any of the provisions which have been proposed, and especially the change of name, because an arbitration center for India cannot be just named as New Delhi International Arbitration Center. It has to be India's arbitration center. So this is a welcome change, because you'll have to bring more units of this in other cities. So naturally, New Delhi cannot be the only place where you have an arbitration center. But while saying this, let me give a little backdrop. India wanted to emerge as a seat of arbitration, and that is why in 1995, and the International Center for Alternate Dispute Resolution, this initiative was taken by the then Law Minister, Mr. Bharadwaj. I was part of that function in Justice J.S. Verma, and all top Supreme Court judges were also present. And the reason was that in world over, all centers which are doing well, whether it be Singapore, whether it be Geneva, whether it be Paris, whether it be New York or London, all centers are run by societies, and society of experts, and a society of people with a lot of credibility. And that is why Singapore is doing very well, exceptionally well. Just to tell you, 54% of people choose Singapore as the seat of arbitration, and 74% of South Asia Pacific region people want Singapore to be the seat of arbitration, even today I'm talking of. While ICARD could attract only 49 arbitration in 2 decades. In 1 year, Singapore had something like 153 new cases. This is 2016. So even Indians today don't choose India as a seat of arbitration. They choose Singapore, they choose London, they choose Paris, they choose Geneva. The reason I'm saying this is because this is also a case of missed opportunities, and I'm sure more opportunities will come after we give suggestions. We have created a monolith which is completely controlled by the government. If you look at the composition under Section 5, it's all government. Moment you make it government, nobody in the business world is going to believe you. In Madhya Pradesh, we created an act for all government contracts. That is Madhyastha Adhiniyam 1982. It was challenged before the Supreme Court, challenge upheld. Today, nobody wants to go to that forum in Madhya Pradesh because you don't get relief. The question is, it is the fairness, the credibility of the forum which decides how popular your seat is going to be. The problem with India is, unless we give this face of neutrality and professionalism to our seat, to a forum, it will not be accepted by the world. Our problem is also inherent in many of the problems of the forum. Today, the fee that is charged by the arbitrators is phenomenal. It's what, sir, they charge for the morning session, then they charge for the evening session, for 2 hours in the morning, 2 hours in the evening, then they have reading charges, they have preparation charges, they have briefing charges. I mean, any lawyer would know that. So if you make your system so expensive, who's going to come to you? And over and above that, you have the lawyer fee. I mean, you have highly paid lawyers sitting in London on VC addressing these arbitrators. So I'm not trying to take away anybody's effort. What I'm trying to say is, unless you professionalize your institution, nothing is going to change.
Silence in the room, please.
The name.
Can we keep silence?
By changing the name, if you could change the character, but sir, by changing the name, you can't change the character of an institution. Name is something very. It's a beginning. It's nothing that will change the confidence of the people, the credibility of the people in those institutions. So my point is, we have decided to change the name. Removing difficulties was inevitable because it was a 1919 legislation. You had given 2 years, 5 years have lapsed. If some difficulties have to be removed, the time had to be extended. We are supporting all that. But the main point is, unless you have a grading system for arbitration institutions, accreditations of arbitrators, mediation is a separate issue, concept altogether. Don't mix up mediation with arbitration. There's a Mediation Act coming separately. We were all part of the JPC, and now that act will itself be a complete code in itself. We'll debate that when that time comes. It's different, because we'll have a lot of things to say there also. But this is an alternative dispute resolution system which needs to be encouraged. India has to become, if we want to make India a powerful economy, a good economy, a blooming business destination, there is no way that we should not be working towards strengthening this institution. But this institution cannot be strengthened because of its present composition character. Most of your arbitration that takes place today is based upon ad hoc appointments. When I say ad hoc appointments, it is a Section 11 appointment under the Arbitration Act, where you go to the court and I appoint one arbitrator, my opponent appoints one arbitrator, and the two arbitrators appoint a third arbitrator. And the feeling that parties have is, my appointee should be my man, that person thinks my appointee should be his man. You can't have a system where the arbitrator is my man or his man. It has to be the institution's man. So, as I said, the whole concept has to change if we want to bring credibility into this institution. Similarly, the fee, the proceedings, all those have to be regulated. Your centers have to be well equipped. You need to have very good centers. I mean, you go to London, we've been for arbitration to London, you see the way it is conducted. The way professionally people come and argue their cases, they go away. You have Queen's Councils and King's Council, all kinds of councils who come there. So my humble submission to the minister is, you've taken the initiative. And fortunately, he's from the same college from where I also studied. It's the Campus Law Center of Delhi. And most of the judges of High Court and Supreme Court are also from that college. So we have an opportunity to make India a destination which it deserves to be, because with the kind of globalization and the expansion of industries that is taking place in India, you need an arbitration center of credibility. But not the kind of arbitrations that are taking place today in India. It has to be different. And then, sir, you can't have layers. You can't have layers and layers of appeals after that. Just 3 days back in Supreme Court, Justice Gawai's bench passed an order that, and it's reported in papers, that if you don't enforce the award, if government doesn't enforce an award and make payments, then what is the point of having an arbitration in India? I mean, if after awards, people have to go to Supreme Court to seek payment of that, enforcement of that award, This itself takes away the credibility of the arbitration process. So my earnest request is, it's a golden opportunity. It's a wonderful, it's an expanding area. It's an area which people would love to enter into. But if you want that area, first decentralize it in the sense, please take the government away from it as much as possible. Bring in experts. Bring in people of credibility. Let them manage these institutions. Professionalize their working systems. Make the appointment of arbitrators an institutional appointment also. And then take it forward in a time-bound manner. People want time-bound awards. People want time-bound adjudication. They don't want layers of because today, after I get an award, I get an opportunity to go to district court, file my objections, then that gets decided, then I go to High Court, then from there I go to Supreme Court. I am appearing in one arbitration of a Malaysian company which has gone to court 33 times because government went to court 33 times to stop that arbitration. And I have won 33 times. And it is still pending in Supreme Court. So it is an unending process. You can't make it like a civil suit. You have to make it as a fast-track arrangement of credibility and concern. And that is what I say, that it's a wonderful opportunity. While we support you in your effort, but we would like you to take your effort forward and make India a great destination for arbitration.
माननीय श्री सुशील कुमार मोदी जी।